Hello, welcome all. So today's topic is all about private placement of securities. So in this video, I'll walk you all through with the meaning of private placement, which securities can be offered through private placement, which company can issue, number of persons, that is limit for making private placement offer, the mandatory requirements, the process part, relaxation available in case of NCD issue, the penalty part in case of non-compliances, and finally the Act and section reference. So be in the video until the end. One more thing, if you haven't subscribed my channel yet, please subscribe and click on the bell icon button so that you don't miss any important videos and shorts. Let's start. So meaning. So what is the meaning of private placement? Private placement means an invitation made to subscribe the securities of the company to selected group of person or identified person. So this identified person or selected group of person are identified or selected by the board of directors of the company. So this offer is particularly made to particular group of persons. Okay. This person can be existing shareholders or new shareholders. Okay. So it is offer made to particular person, group of persons through private placement offer application letter. Okay. Now coming to next, which securities can be offered? So equity shares, preference shares as well as debentures can be offered through private placement. Now, which company can issue private as well as public? Both the type of companies can issue securities through private placement. Number of persons. So, private placement offer can be made up to 50 persons at once, okay, which excludes the employees of the company and qualified institutional buyers. And up to not more than 200 in the financial year, that is up to 200 in the financial year. So if I am making offer in whole financial year, the number of persons should not exceed 200 for the particular security. So it is calculated basis on the type of security. That means for equity the limit is 200, for preference shares limit is 200, for debentures limit is 200. Okay, and which excludes the employees as well as qualified institutional buyers for calculating this number. Okay, now requirement. So there is requirement of taking valuation report from the registered valuer. Okay, basis on the valuation report and basis on the price of the security, the offer can be made at that price. Okay, further the issue price can be more than the valuation price, but it cannot be offered below valuation price. Okay, it can be offered at premium but not at the discount. It can be offered at valuation price or more than the price of valuation. Now identified person list. So this list is identified by the board of directors of the company. Board is having power over this, and you have to check the articles of association. So is there any restriction or is there any additional requirement other than Companies Act requirement for doing the private placement offer? So check the articles of the company. If there is required to amend the articles, then do first amendment process and then proceed with this private placement offer. Next process part. Okay, so in process I'll go step by step. So first step is take the approval in the board meeting. Okay, so first for the list of persons, so identify list of persons is decided by the board. Then draft offer letter, that is draft private placement offer cum application letter. This is approved by the board. Then take approval for the private placement proposal and decide the EGM date, time and place. Okay, for taking the further shareholders approval. So this was the first part. Now second step, call EGM. Call EGM. So here I have mentioned EGM because it is not required that EGM will be scheduled. EGM conducts only once in a year. So in other than that case, EGM is required. So call extraordinary general meeting. Here the approval of shareholders for private placement can only be taken by passing special resolution. So it is clearly mentioned in the Act that special resolution is required. Okay, so approval by special resolution only, both in case of private or public company, for private placement offer and draft offer document. So draft offer document is prepared in the form of pass 4. It is given by the Companies Act. Okay. Now point number 3, file MGD 14 within 30 days of passing special resolution. That is the special resolution which is passed for approval of this private placement offer in the EGM, passing a special resolution in EGM within 30 days. Okay. It is non-STP form. That means generally MGD 14 is STP form. That means it is system approved, automatically approved by the system. But for this purpose, this is non-STP form. That means particular ROC will approve, will give approval for this MGD 14. Here the MGD 14 is required to be filed both by private as well as public company, because here it is not any exemption from filing this MGD 14 for this special resolution. Okay. In MCA notification also it is clearly mentioned that it is exempted from filing MGD 14 for the resolutions which are passed under section 179, which are powers given to the board of directors. But for the special resolution there is no exemption. That means MGD 14 is mandatory, required to be filed by private company as well. Next, send private placement offer cum application letter in the format of PAS 4 only after approval of this MGD 14, and timeline is within period of 30 days from the recording the names of the selected persons. This private placement offer cum application letter is serially numbered. It is individually sent and addressed to that particular person. It can be sent either in writing, in physical mode, or electronic mode. Okay. Maintain the record of all the private placement offer and acceptance in format of PAS 5. So PAS 5 is again given format in the Companies Act. Okay. Now earlier it was required to submit file PAS 4 and PAS 5 via GNL2, but now it is amended and now it is not required to file the PAS 4 and PAS 5 with the ROC. Okay. However, the PAS 5 is filed as an attachment with the form PAS 3, that is return of. Next, conduct board meeting for taking approval for issue and allotment of securities. So there is timeline for this allotment. Allotment should be made within a period of 60 days from the receipt of application money. Okay. Now one more thing I wanted to highlight here, that application money must be received via check or demand draft. It cannot be paid in cash. So once the offer letter is circulated, the person to whom offer is made which accepts it, and it pays the application money via demand draft or the check. Now the company has to open a separate bank account for receipt of this money for the offer made through private placement. Okay. Next, file MGD 14 for issue of securities within a period of 30 days of passing board resolution. So this filing of MGD 14 is mandatory for private companies as well, because in the act there is clearly mentioned that private company is required to file MGD 14 for this purpose. Okay. Next, file PAS 3. PAS 3 is the return of allotment of securities within a period of 15 days of allotment of these securities. Here the timeline is 15 days. Okay. Generally the forms are required to file within 30 days, but it is clearly mentioned for private placement offer the company has to file PAS 3 within a period of 15 days from the allotment. Now next, so this was all about the process part. Now coming to next, what are the relaxation provided in case of issue of non-convertible debentures through private placement offer. So if the issue, so offer made, if the issue is within the limit of section 180. So section 180 provides that borrowing power to the company. So if it is within the limit, I am not going into deep for the section 180. So if it is within the limit, board resolution is sufficient. That means that company is not required to file pass special resolution in the EGM. Okay. Next, if the issue size, this is proposed issue. Okay. Issue means proposed issue, exceeds the limit of section 180, then in such case BR is required plus SR. So here the special resolution can be passed for the whole year. Suppose I can pass this in the first board meeting, say conducting in the April or May month. So I can give the proposed amount, say 5 crores, say 10 crores for the whole year, for the entire year. So if it is within that limit, then I didn't require to go again with the shareholders for taking approval. So I can take once in advance approval for the entire year issue. Okay. So SR is required once for all offers. Okay. Now here the BR is required basis on the particular offer. Okay. It is required to pass on the offer basis. So this further relaxation provided to NCD issue. Now exception is there for non-banking finance company NBFC registered with RBI and housing finance companies as registered with the National Housing Finance Banks. So this regulations will not applicable for this NBFC and housing finance company in case there are particular regulations provided by that particular act, say RBI Act, say National Housing Finance Act. Then that companies are required to comply with that provisions, and they are not required to comply with this Companies Act provision. Okay. Next, penalty part. So in case of contravention of these provisions of private placement offer, the penalty amount mentioned is up to amount of private placement offer or 2 crore, whichever is lower, and the company has to refund the entire money to the subscribers within a period of 30 days from the receipt of the penalty order. Okay. Now, in case of failure to file tax 3, that is return of allotment, the company director and promoters will be penalized with 1000 rupees per day, during which contravention continues up to 25 lakhs. So the penalty amount is very huge. So you have to comply with this provision very strictly. Okay. Now, Act or Section reference. So, Section 42 of the Companies Act provides the provisions related to private placement offer and companies, prospectus, and allotment of securities rules 2014. In this rules, sub-rule 14 particularly provides the provisions related to private placement in detail. Here MCA notification dated June 5, 2015. Point number 8. This particularly provides from filing MGT 14. So this point number 8 provides that private companies are exempted from filing MGT 14. So here I have mentioned that notification. This is for the private company. However, for this MGT 14, for issue of securities, it is mandatory for the private company to file MGT 14, as it is clearly mentioned in the Act. Okay, so this was all about the private placement offer. I hope it is helpful. If you still have any query or any suggestion, please write in the comment section. Stay connected for more videos. Bye.